ready? Raise. Down. Got in station, please switch off your mobile phone and not to disrupt today's proceeding. Today's proceeding magistrate is Tuan Ahmad Haizan bin Abdullah. Criminal case number 0016/12/04, Victory against Peer Pratap Singh.
I am the magistrate. I am Nurhuda Muhammad Khan, prosecution officer for this case.
Okay.
Tuan Magistrate, I am Rosmaihan Ismail and my partner Hamidah Salamu from Ida Khan and Co. presenting our client Mir Pratap Singh.
This is a case of possessing drug which fall under section 12 subsection 2 of Dangerous Drug Act 1952. The accused in this case is Mir Pratap Singh.
Pratap Singh. Dear Pratap Singh, debut on 1st December 2004 at about 10 p.m. at Fatimah Snooker Center, number 2000, Jalan SS1/1 in the district of Klang, in the state of Selangor, was found in possession of 0.06 grams of powder substance i.e. heroin, and that it have committed an offence under section clause 2 Dangerous Drugs Act 1952 and also punishable under the same act. Do you understand with the charge?
Yes. Okay. Well, Pratap Singh, you have been charged under section 12(2) of the Dangerous Drug Act. Before I proceed with the case, I'd like to explain to you that under the Dangerous Drug Act, under section 12(2), it carries a maximum jail term of 5 years and a fine of 100,000 ringgit. So before you make any plea or you answer the charges, I want you to know this so that you make a right decision to plead guilty or to claim trial to this charge. What is your claim?
Not guilty.
Not guilty.
Claim for trial.
Okay.
To a magistrate, I ask for adjournment for this case. I haven't received chemist report yet. The officer in charge told me that he needs some more days to complete the report.
Counsel, do you have any objection?
I have no objection to a magistrate as this is a bailable offence, so I ask your permission to grant bail for my client.
So, prosecutor, do you have anything to say?
Yes, I ask your permission to set bail at 5,000 ringgit with one surety.
Counsel, any objection to this request?
To a magistrate, I'm asking for reduction of the amount of bail from 5,000 ringgit to 1,000 ringgit because the bail is too high for my client. Basically, as a waiter, my client's salary is about 1,000 ringgit per month. For information, his wife had passed away 2 months ago, and he needs to maintain his 5 children, aged in between 6 to 17 years old, who is in secondary and primary school. And at the same time also, he need to take care of his mother-in-law who is suffering from blood cancer. So by considering this matter, his monthly salary is only enough for himself and his family. So by considering this matter, the amount suggested by prosecutor is irrelevant. I hope the magistrate will take it into consideration of these circumstances to reduce the amount of bail.
But counsel, are you sure that your client will come to the court if they set amount below the amount of 5,000 ringgit? Because based on my experience, with the lower amount of bail, most of the accused state before granted. Let me just finish my word first,
For
okay?
reduction of bail for my
Come on,
client.
prosecutor and defense counsel, can you come to the bench, please? When you are fighting up the cases, don't raise your voice because there's a lot of people. This is a court sitting, so respect the chair and go according to the procedures. I don't want any contempt of court. Understand? Lower down your tone, and you have your case to fight out, then you just tell me what is your reasons, then I'll consider things. Okay, back. Okay, defense, you can continue with your...
Thank you, to magistrate. To magistrate, I want to stress again that the amount of bail should be reduced to 1,000 ringgit. In fact, I can't see any relevancy to fix the high amount of bail to ensure the appearance of my client to the court for the next session. Anyway, I'm referring to the case of Ching Chi Kiang against PP. So, this is the case. Okay, in case of Ching Chi Kiang against PP, there was a breach of trust case which involved 100,000 ringgit. However, the amount of bail is only 1,000 ringgit. So, in this present case, the amount of drug is below than 1 gram. So, so it is relevant to have the bail only 1,000 ringgit.
I object with the amount which asked by the counsel, because I think if the bail fixed at 5,000 ringgit, it will make the accused more responsible to appear because the said amount is very high. Otherwise, it might go on just like that.
Lord Magistrate, I think the argument made by the prosecutor is relevant regarding the appearance of my client and the higher amount of bail, 5,000 ringgit. I'm sure that my client is a responsible person as he attends to the proceeding. So, I guarantee that there is no problem for my client to attend for next session.
I still stand that bail be set at 5,000 ringgit.
Depends. She still stands at 5,000. I mean, the prosecution stands at 5,000. Anything else you want to say about your bail?
Yes, Sir Magistrate. I would like to draw the court attention to the case of law. Firstly, in So Seok Leong against PP, in this case, the court had laid down the factors for consideration in setting the quantum of bail. Firstly, the nature and the gravity of the offence. Second, the quantum should be higher in the case of non-bailable offence. Third, excessive amount will defeat the granting of bail as the accused may find difficulty in getting a bailer acceptable to the court. And four, it is a well-known principle actually. The principle of the criminal law, the accused is presumed innocent until proven guilty. Fifth, whether there is likelihood of the accused absconding if the bail quantum is set at too low. Sixth, bail is not intended to be punitive in nature but only to secure the attendance of the accused of trial. And finally, the quantum should not be set so prohibitively as to have the effect of incarcerating the accused before he is convicted of the crime. So, besides, this principle has been taken for consideration in the case of Manikan against PP. Therefore, I really hope that the magistrate will reduce the amount of bail to 1,000 ringgit by considering these two cases. Thank you, Magistrate.
Okay, after considering the arguments by both the prosecution and the defense, I think I'll come to a rational amount to be given as prosecution have demanded for $5,000 bail to be set at 5,000, and the defense is asking for 1,000. I think for this case to be reasonable to both parties, I think I'll set, or no, I'm going to say that I'm going to set bail at 3,000 ringgit with one surety. Okay. Thank you to our minister.
Criminal case number 014/12/14 against Rosmawa binti Jati.
Tuan Magistrate, my name is Amir Bushari Mamadanusi as the prosecuting officer for this case. Thank you.
Tuan Magistrate, my name is Azura Idris from Mahama & Co. I'm acting on behalf of my client, Rosmawa binti Jati.
Tuan Magistrate, this is a case against Mr. Rosmawa binti Jati for assault under Section 352 of Penal Code.
Rosmawa binti Jati.
My apology, Tuan Magistrate. I would like to ask your permission because my client could not reach the court in time because she had a problem with her car. So, I seek your approval for adjourn this case for a while.
Prosecutor, do you have anything to say?
Yes, Tuan Magistrate. For your information, this case had been postponed twice and the accused is aware about this. Therefore, I would like to apply for warrant of arrest because the summons has personally served to the accused. Thus, I can see any relevancy to adjourn this case again.
Once again, Tuan Magistrate, I seek your approval to adjourn this case for an hour because my client is on the way.
Are you sure that she will be coming to the court?
Yes, Tuan Magistrate, because she already called me and she informed that she will come for perhaps in one hour, and then because she had no intention by giving me a call, so it proved that she has no intention not to appear to the court for today's proceeding.
Okay, both the defense counsel and the prosecution are recorded as what the defense counsel has asked for. So the court grants adjournment to this case for an hour.
Thank you, Tuan Magistrate.
Thank you, Tuan Magistrate.
Fazina, proceed with the next case.
Criminal case number 015/12/04 Muhammad PP against Muhammad Fakhruddin Ibrahim.
Tuan Magistrate, I'm Amir Bushari Mamadanusi for the prosecution.
Tuan Magistrate, I'm Halimah Azidin from Rani & Co. Advocate and solicitor on behalf of my client, Muhammad Fakhruddin Ibrahim, seeks an application for the postponement of the case due to urgency of my client. My client cannot come to the court today because some health problem and he is admitted to the hospital. And I had a discussion with the prosecution and we had agreed to have a new mention date on 30th of December 2004.
Prosecution, you have anything to say?
Actually, we had already agreed on this matter.
Okay, do you have any MC for your client?
Yes, Tuan Magistrate.
Is on that day?
Yes, you have another trial on that day. The only free date is 4th January 2004.
Counsel and prosecutor, do you have any objection with the new date mentioned just now?
I have no objection, Tuan Magistrate.
However, Tuan Magistrate, I have another hearing on that day. So, how about 6 January 2004?
Fazina, please check on my schedule or my diary that I have any cases on that day.
No, Tuan Magistrate.
So defense counsel, is it okay on the 6th?
Yes, Tuan Magistrate.
Then because both the prosecution and the defense agreed, the new mentioned date for this case will be held on the 6th of January 2005.
Thank you, Tuan Magistrate.
Thank you, Tuan Magistrate.
criminal case number 014/12/14 PP against Rosmawa binti Jati.
I'm sorry, to my magistrate. It seems that my client had not come, so I also couldn't reach to call her, and then perhaps she is not coming.
Prosecution, have you anything to say?
To my magistrate, since the accused failed to attend for today, I would like to apply for warrant of arrest.
This is the second or third time that she never appeared in court.
Basically, including for this day, it is for the third time. She failed to attend.
So, counsel, what do you think?
It's up to the court discretion.
Okay, due to not attending the case today, and this has been the third time that she never failed to attend to the court, I hereby issue a warrant of arrest for Rosmawa binti Jati.
Thank you, to my magistrate.
Fazila, do you have any other cases today?
No, to magistrate. That's the only cases for this manifestation to magistrate.
Okay, then the court will disperse.
Court